Case that pit law enforcement officers against members of their own team. Word now from the state's highest court that the Kent County law enforcement violated the Constitution and how they handled the drug investigation into now fired county officers. That move sends the case back to court to determine whether the entire case against two county jail officers will stand. Our own Barton Dieters has covered this as the case has transpired for the past 3 years. He's in the control room tonight with the latest. Barton.
Right, Leanne, it was March of 2014 when Kent County Sheriff Larry Stelma told 24-Hour News 8 that 4 officers had been arrested after it was discovered they had possessed various amounts of marijuana butter. It was clear from the beginning that these officers were going to face the full force of the law.
It's certainly disappointing, and I'm greatly dismayed that officers would be involved in this type of activity.
The 4 correction officers arrested in 2014 and charged were Sergeant Tim Bernhardt and officers Brian Tennant, Mike Frederick, and Todd Van Dorn. All were fired.
I think it's disappointing, and I'm dismayed that it really tarnishes the badge for anybody that wears a badge.
Bernhardt and Tennant pleaded guilty to maintaining a drug house, but Bernhardt would kill himself before sentencing. The remaining officers appealed, saying that the way police handled the investigation violated their rights. Police did not get a warrant, but instead showed up at the homes in the pre-dawn hours for a so-called knock and talk, where police show up at a house and simply ask for consent to come in and interview someone. Van Dorn's attorney, Bruce Block, has argued from the get-go that the late-night warrantless questioning of the officers violated the Constitution.
If a Girl Scout can't come to your house and sell cookies at that hour, the police can't either, because they're bound by that same social norms.
The Supreme Court opinion says the unreasonable hour clearly violated the suspect's rights.
The Supreme Court of Michigan has not ruled on knock and talks. This is the first time they've ruled on it. The knock and talk procedure is becoming more common, much more common than the traditional ways of gaining information.
Block says this is about more than just his client.
This was an exceptional day for the Fourth Amendment, something that is near and dear to my heart.
As for the fired officer,
as far as his job, I'm not entirely convinced he couldn't get his job back.
Now the case goes back to the same court where it began years ago. The judge there will have to determine if there's any other way the evidence against the officers could be admitted. We reached out to the Sheriff's Department today for comment, but have not heard back. Live in studio control, Barton Dieters, 24-Hour News 8.
All right, Barton.